Last time in episode 31, we heard Lieutenant James Lenk take the stand for the first time. He walks us through his background, his role in the investigation, and most importantly, his connection to the discovery of that infamous Toyota key in Stephen Avery's trailer. We also talked about the timing of the searches. 3 hours spent inside Avery's not so cluttered trailer, but barely 90 minutes in a jam packed garage, or at least that was Link's portion. Maybe there were other people there. I don't know. And somehow, despite multiple searches of the same small bedroom, the key just all of a sudden appears conveniently. And guess what? The two officers tied to Avery's $36 million lawsuit, Lenk and Colburn, are the ones closest to it. Now, in this episode number 32, we pick right up where we left off. Lenk is back on the stand, and this time, the testimony digs even deeper into this so-called discovery of the key, the chain of custody, and his knowledge, or lack thereof, about Stephen Avery's blood vial. And then we'll hear the defense start pushing back. We are now in day 8 of the trial, and the questioning of Lieutenant Lenk continues, or the direct examination of Lieutenant Lenk continues. If you're one of those people who want more bonus content and early access to every episode, Patreon is where this all lives. I'll have the link in the show notes for you. And again, the direct examination is being done by Attorney Kratz. Good morning, Lieutenant, and welcome back. We left off yesterday having completed the search efforts that you and other law enforcement officers did on the 6th of November, which was Sunday. We're going to move to Monday now, the 7th of November. Ask if you were asked to return to the Avery salvage property. Yes, I was. Upon your return on the 7th, who were you assigned to work with? On the 7th, it was Sergeant Bill Tyson. Can you describe for the jury, please, your role on the 7th? That is, what responsibilities and duties were you given that day? I believe Sergeant Tyson was given the information to open all the trunks of the cars near the buildings or in the buildings on the property that hadn't already been opened, and to collect firearms from all the buildings. Did you assist Sergeant Tyson in that effort? Yes. About how long did that take? At least your part of the trunks and the vehicles that you were searching through. My guess would probably be an hour and a half to 2 hours. After that effort, what did you do then? I believe Sergeant Tyson, or we went back to the command center to get another assignment. Do you remember what your next assignment was? I think at some point we were told to go back to the Avery trailer and get some numbers off a computer, I believe. All right. Did you do that with Sergeant Tyson? Yes. Thereafter, were you asked to do something else? I'm sure. I don't recall right now. All right. Nothing that sticks out in your mind, at least nothing of a substantial evidentiary nature. Is that right? That's correct. The next day then, on Tuesday, the 8th, Lieutenant Lenk, did you once again return to the Avery salvage property? Yes, sir, I did. And on Tuesday, the 8th of November, who were you assigned to assist? I was assigned to assist Deputy Kucharski. And again, for the jury's benefit, since they haven't met Deputy Kucharski yet, who does he work for? He works for the Calumet County Sheriff's Department. Were there any other members of your search team that day? Myself, Sergeant Colburn, and Deputy Kucharski. And where did you guys first go? We first went to a yellow vehicle that was parked in front of the office area to retrieve a couple firearms out of the trunk. Now, once again, Lieutenant, I asked you this yesterday, but on the 8th of November, And in every other day, did you know what your responsibilities were going to be when you got to the Avery salvage property? No, sir. Did you know in which buildings you were going to be assigned? No, sir. Did you even know if you were going into any buildings? No, sir. What was the next assignment you received on the 8th? After we retrieved the firearms from that vehicle, Deputy Kucharski received information to go back to the Stephen Avery trailer. And what was the nature of this particular assignment? That was to specifically collect magazines and pictures, trying to think, the computer-related items. I'm not sure if there was anything else specifically that was there a search to be performed of other rooms within that home as well? That's correct. Can you describe that kind of search and whether or not that was different than one that was performed earlier in the week? This would have been a much more specific search. We were given items to look for. We were also told to do a thorough search of the dwelling besides the items that were given. This thorough search, did it include the bedroom of Stephen Avery? Yes, sir, it did. I'm going to show you what's been received as exhibit number 103. It's a computer animation. I'm going to zoom into the bedroom area. Ask if that's going to assist you in describing your search of the bedroom that day. Yes, sir, it will. Okay. Was this bedroom thoroughly searched by yourself, Sergeant Colburn, and Deputy Kucharski from the Calumet County Sheriff's Department? On 8th? Yes. Yes, sir. Sometime towards, well, let me back up just a minute. Were you in close enough proximity that you were able to see Sergeant Colburn in that bedroom? Yes, sir. Referring to Exhibit 103, is this a large bedroom? No, sir, it is not. Were you able to see Deputy Kucharski? Yes, sir. Do you recall, Lieutenant Lenk, a pair of bedroom slippers being in this bedroom? Yes, sir, I do. Could you just, using the laser pointer, and just point to for the jurors about where those were located? Approximately right in there, right next to what we now know as a bookcase? Yes, sir. Did you have occasion to inspect or look at those bedroom slippers? Yes, I did. Describe that for the jury, please. When we first came into the bedroom, the slippers were sitting there. I just picked them up, looked inside, and put them back down. Did you look underneath them? Yes, I did. Did you notice anything underneath the slippers when you looked under them? No, sir, there was nothing there. Thereafter, or sometime during the search, were you aware of and did you see Sergeant Colburn manipulating or moving a piece of furniture now known as the bookcase? Yes, sir. After replacing or pushing back the bookcase, what did you do? After the magazines and a binder were pushed back into the bookcase, I advised Deputy Kucharski that I would go out into the living room and retrieve bags or try to get boxes to put the items that we had recovered. Did you do that? Yes, I did. On your return to the bedroom, tell the jury what you saw. When I entered the bedroom, I caught my eye. I saw a key laying in front of the slippers by the back corner of that cabinet. Now, before Sergeant Colburn's manipulation or banging around of that piece of furniture, had that key been there? No, sir, it was not. If you could use your laser pointer again, tell the jury about where in that bedroom you were standing when you saw the key and where was the key. I was coming in that door and the key was right at the back corner of that cabinet on the floor. There's been another exhibit which has been admitted into evidence. It's exhibit number 210. Actually, a photograph. I'm going to show that to you at this time and ask you to tell the jury what we're looking at. You're looking at the cabinet with the slippers and the key that was laying on the floor. And that image, that view, is that what you saw on the 8th of November? Yes, sir, it is. After seeing that key, did you direct any activity or was any activity decided between the three of you? I informed the other two officers that there's a key laying on the floor and it was not there before. They all looked at it. At that point, Deputy Kucharski photographed it and subsequently collected it. How did he collect it? Did you witness that? He had gloves on. He collected it. I believe he put it into a evidence bag. Now, Lieutenant Lenk, let me just ask you, were you surprised to see that key? Yes, sir, I was. Why? It wasn't there before. At that time and at that early time in observing the key, did you believe that it had obvious evidentiary value? When we looked at the key, it appeared to have a Toyota emblem on the key itself. At that point, we thought it may have some significant value. After Deputy Kucharski photographed and collected the key, do you know what was done with it? Deputy Kucharski contacted the officers in charge of the case, Agent Fassbender and Investigator Wiegert, told them what he had found, and they subsequently came to the trailer. Was the key provided to them, if you know? I believe at that time it was shown to them, and they said they would send someone back to collect the key. All right. Now, Lieutenant Lenk, at that moment, that is, after the collection of the key, did you, Deputy Kucharski and Sergeant Colburn, attempt to ascertain where the key had come from or do some further investigation? Yes, we did. Tell the jury what kind of investigation you did, please. We looked at the cabinet. At the back corner of the cabinet, we saw that there was an opening between the back of the cabinet and the side, approximately a half to an inch, and we believed that's where the key had fallen from the cabinet. Can you point on exhibit number 210, the back corner where the cabinet had been pulled away? Right back in there. Let me show you another exhibit, Exhibit 169. It's already been admitted into evidence. Ask if you recognize that exhibit. Yes, sir, that is the cabinet we're talking about. Could you point to the area of the back panel being pulled away that you've been describing? Right there. And again, recognizing that this photo was taken on a different day other than the 8th, does exhibit number 169 look the same as it did that morning on the 8th of November? Yes, sir, it does. Lieutenant Link, after noting the defect or the abnormality to the camera, did you have any further discussion with your fellow searchers as to finding this key? Yes, we discussed the fact that it had to have come from that cabinet and probably from all the jostling and tipping of the cabinet. After completing the search, what you now described, a thorough search of the interior of the Avery trailer, what was your next responsibility? I'm not exactly sure what we did after that. Do you remember searching any other buildings that day? Yeah, we had searched other buildings. I'm not exactly sure which ones they were. Let's talk about timing, or at least time frames, the rest of your day. Do you know what you did, at least generally, the rest of your day? In other words, what general responsibilities you were given? Whatever responsibilities were given to Deputy Kucharski that day, we assisted him. Our primary responsibility were searching buildings. I see. And just so that jury's not left to wonder, was there anything, at least that you believed, that was of substantial evidentiary value found in the rest of your searches that day or that afternoon? No, sir. On the 9th, that is the next day, Wednesday, were you asked to return to the Avery salvage property? Yes, sir, we were. And what were your responsibilities that day? I was assigned with also Sergeant Colburn to Deputy Wendling to assist him in searching. Who's Deputy Wendling? He's an officer with the Calumet County Sheriff's Department. As part of Deputy Wendling's team on the 9th of November, were you asked to perform any searches that day? Yes, we were. Do you remember where you searched that day? We went back to the Stephen Avery trailer and we also searched his garage. Were you looking for something specific in the trailer? We were looking for a garage door remote and a pair of women's gloves. Did you find either of those items? There was a pair of women's gloves found in a paper bag underneath the desk. The last area of inquiry I have, Lieutenant Lenk, actually relates to other connections or other items that may be located in Manitowoc County. Let me specifically ask you whether you have ever seen any vial of Mr. Stephen Avery's blood in possession anywhere in Manitowoc County. No, sir, I have not. Did you ever, before the 5th of November, have knowledge of a vial of Mr. Avery's blood in the Manitowoc County Clerk of Court's office? No, sir, I did not. Did you ever see a vial of blood in the clerk's office? No, sir. Between the 3rd and 5th of November, were you ever in the Manitowoc County Clerk of Court's office? No, sir, I was not. Lieutenant Lake, did you ever obtain any blood from the clerk's office, or did you obtain any blood from any location and plant it anywhere on the Avery salvage property? No, sir, absolutely not. Did you ever plant it anywhere in Teresa Hallbach's vehicle or anywhere where it could be found as part of this investigation? No, sir, definitely not. Did you ever assist any other officer so that another officer could either plant evidence or try to, in some way, frame Mr. Avery for this homicide? No, sir. And lastly, had you ever heard from any member of the Manitowoc County law enforcement community that they had participated in some frame-up or planting of evidence? No, sir, there was not. And just to make sure, since we've gone through the key evidence, did you have any occasion to plant the Teresa Hallbach's key or place her key in Mr. Avery's residence? Absolutely not. Attorney Kratz then says, that's all the questions I have of Lieutenant Link, Judge. Thank you. The court then says, Mr. Strang. And Mr. Strang, one of Stephen's defense attorneys, says, thank you, Your Honor, and he begins his cross-examination. Next year, it will be a quarter century that you've been involved in policing in one department or another. Lieutenant Link? Close to a quarter, yes. You have, in the Manitowoc County Sheriff's Department, obtained what? The 4th highest rank in that department? Yes, sir. Mr. Kratz, just a minute ago, asked you whether you had ever heard from any member of the Manitowoc County Sheriff's Department, any member that they had participated in a frame-up or planting evidence, concocting a case against Mr. Avery. Remember that question? Yes, sir. And your answer was no. You had not heard from any member of the Manitowoc County Sheriff's Department that they had done anything of the sort? That's correct. That includes about the 1985 case against Mr. Avery, doesn't it? I'm not sure. Not one of the officers of that department has ever told you that they had anything to do with the wrongful conviction in 1985 either, have they? No one's ever told me they had anything to do with the wrongful conviction. You worked with Sheriff Peterson for a number of years? Yes, sir. You knew him to be directly involved in that earlier case? Yes, sir. And no one ever admitted doing anything wrong in connection with that earlier case to you, did they? Not to me, no, sir. Now, do you suppose, Lieutenant Link, that if an officer, let's use you, do you suppose that if you had taken a vial of blood from the clerk of court's office, planted it, or caused it to be planted in Teresa Hallbach's vehicle, and told no one before today, do you suppose that if a defense lawyer stood up and asked you, did you plant blood in Teresa Hallbach's car, do you suppose you'd tell me? Yes, sir, you would. I did not. And if you had done it, do you think you'd admit it here under oath? I didn't do that. It's ridiculous. Would you admit it under oath? If under oath, I would admit it. Yes. I'm sorry. If I did it, I would admit it. You would admit. Now, you know that planting that blood would have at least been a crime under Wisconsin law? Yes, sir. It probably would have been a federal crime as well, correct? I'm not positive to that. I don't know. To the extent that you were seeking to deprive someone, Mr. Avery, for example, of his civil rights, it would have been a federal crime as well. I wasn't trying to do anything to deprive him of his civil rights. I understand that your testimony, if you or someone else had planted evidence, you expect that would have been a federal crime as well? If it had been planted, yes. All right. And your testimony is that you'd come in here and because some defense lawyer asked you, you'd confess this to 12 jurors. Had you done it? I probably would if I had done it. All right. Would you expect every member of the Manitowoc County Sheriff's Department to do the same thing? Attorney Kratz then says, objection, speculation, judge. The court says sustained. And then Attorney Strang continues. You ran briefly through your history with the Manitowoc County Sheriff's Department. I think you started in the jail? Yes, that's correct. Became a sworn officer? I was sworn when I started in the jail. Oh, I'm sorry. Was that a sworn position, not an unsworn position when you started in the jail? Yes, sir, at that time. Okay. It changed later before Sergeant Colburn started in the jail? Yes. All right. Do you know a woman in the clerk of court's office by the name of Teresa Shibesta? No, I don't know that name. Teresa in the clerk of court's office. I'm talking about the Manitowoc County clerk of court's office? No, sir. All right. Did you at any time during the course of your probably early career serve at times as a bailiff for the Manitowoc County Circuit Court? No, sir, I don't think I've ever served as a bailiff. All right. If she says that you had, she's simply mistaken. To my knowledge, I don't believe I served as a bailiff. Well, you would know, wouldn't? Right. You. Okay. And you don't recall ever serving as a bailiff? No, I don't recall at any time. All right. Now, in 2002, you had moved into the Detectives Bureau about 4 years before that? Yes, sir. Okay. In 2002, while serving in the Detective Bureau, you were something called a designated evidence custodian for the entire department. I was an evidence custodian, yes. And by evidence custodian, what that means is that you had overall responsibility for keeping custody or track of all evidence that the Manitowoc County Sheriff's Department may have in its possession. All evidence that was actually in the evidence room. Yes, sir. Okay. And we're going to explain that. Your department maintains an evidence room, right, which is a locked area of the Sheriff's Department? Yes, sir. Only the custodian and probably the sheriff or somebody immediately under the sheriff has a key to that evidence room? Yes, there's actually myself and another officer and the sheriff. But it's a separate locked area within the department. That's correct. You know, while any deputy may have a key to the front door, so to speak, access to the evidence room is closely limited. That's correct. The custodian is one of the small number of people with keys to that room. Correct. There are also things called evidence lockers in the sheriff's department. Yes, sir. They're called temporary evidence lockers. And the way those are used is if an evidence technician or some other officer is out at a scene, collects one or more pieces of evidence for temporary safekeeping, they will bring those back and lock them in a temporary evidence locker. Correct? That's correct. At the first reasonable opportunity to turn them over to the evidence custodian, those items will be turned over to the evidence custodian. Actually, those items are locked into the temporary locker. That key is placed into a lockbox which is retrieved by the custodian who's able to do that. And the custodian actually then takes the evidence out of the locker. That's correct. All right. There's some paperwork completed to document that chain of who's got their hands on the evidence, so to speak. That's correct. Or who's responsible for it. Yes. The evidence custodian prepares that paperwork to document, the evidence away from tinkerers to revelers to chance. That's correct. All right. And then the evidence goes into the evidence room. Correct. Where it's cataloged in some fashion or some record is kept of what's shelf it's on or its location and the door is locked. Correct. That was your responsibility in 2002. Yes. That's the year that a judge, Judge Hazelwood of the Manitowoc County Circuit Court, signed an order that some evidence from the 1985 case against Mr. Avery should be transferred to the state crime lab in Madison. Do you recall that? Yes. As part of that process, evidence had to be obtained from the 1985 file at the clerk of court's office? Correct. Your best recollection is that you did not do that directly? No, sir, I did not. You think perhaps a deputy named Mike Shalou was the person who went over to the clerk's office to pick up the evidence? Yes, sir, he was. You were the person who checked the evidence room in the sheriff's department for any remaining items from the 1985 case file against Mr. Avery on that particular date in 2002. I think on that particular time, I was just filled out a transmittal form for the evidence that was in the clerk of courts. Attorney Kratz and says, Judge, I am going to request a sidebar if we're going into this issue, or perhaps maybe a hearing outside the presence of the jury might be more appropriate. And not to be dramatic, but 3 out of 4 of you aren't subscribed. Why? It's free, it's easy, it's a 1-second button click, and best of all, it makes sure you actually see when a new episode drops. No guessing, no searching, no algorithm roulette. Hit that button now. The court says, all right, let's excuse the jury for a few minutes. I swear, Kratz is constantly doing this. Constantly. All right, so the jury leaves, and it says the jury is out at 9:31 a.m., and then the court says, Mr. Kratz. Attorney Kratz then says, thank you, Judge. I am going to interpose an objection. Based upon pretrial hearings, this particular piece of evidence or the transmittal of this evidence did not include the blood vial. Mr. Strang knows that. I believe that this is an intentional attempt by Mr. Strang to mislead the jury. That is to suggest that the blood vial was part of this transmittal. It's not the blood vial. The blood vial's not involved in this particular transmittal. Or if this witness had nothing to do with the blood vial, it is irrelevant. I'm asking for an offer of proof. I'm asking that this court make a ruling at this time as to whether or not this is relevant. If it is, and if Mr. Strang has a good faith belief as an officer of the court that, in fact, the blood vial was part of any transmittal or part of this witness's connection to it, then I will happily withdraw my objection. But the court says, just a second. Attorney Kratz says, before the court says, Mr. Lenk, I'm going to ask you to be excused from the courtroom as well. Attorney Strang says, that's fine, but that's fine. It's not worth the candle. The court says, all right, I think the victim/witness coordinator will, the witness says, okay. And the court says, escort you out. Mr. Attorney Kratz says, and the court says, Strang, sorry. Attorney Kratz says, I'm sorry. And just to conclude it then, Judge, I am just asking for that pretrial ruling. And if necessary, and before any further contamination or infection of this jury occurs with irrelevant evidence, I'm asking for a ruling by the court, an evidentiary ruling. That's all I have, Judge. Thank you. The court says, are you Are you referring to the exhibit that you just received a copy of? Attorney Kratz says, I suspect that this is the first of several exhibits or at least the first of a line of questioning where Mr. Strang is going to ask about this particular evidence, which Mr. Strang knows or should know included some hair and some fingernail clippings, and that was it. If he has other information or something that we haven't litigated ad nauseum yet to this point, then I'd be very happy to hear about that. The court says, Mr. Strang. Attorney Strang says, I'm going to specifically establish that the blood did not go to the crime lab in 2002, that it's hair and fingernail cuttings that went. And I'm going to explore Mr. Lenk. I believe it would be Mr. Lenk's writing. He'll acknowledge that the items that were sent were exhibits held by the court since the end of the trial. Not only I'm not going to suggest that blood went, I'm going to establish that the blood was not sent to the crime lab because it wasn't. The court says, addressing the issue of relevance, what is going to be the relevance of the evidence? Attorney Strang says, in 2002, either Detective Lenk or someone working under his direction went to the court file, looked through it, extracted hair and fingernail cuttings, which were exhibits held by the court since the end of the trial and were contained in one box. Those were to be tested for DNA procedures. Attorney Kratz says Mr. Strang knows District Attorney Fitzgerald went through the file and Mr. Shalhoub was nowhere there. I want to know if there's going to be a witness that connects the Manitowoc County Sheriff's Department with that vial of blood. That's my objection, Judge, because I think our pretrial hearings on this, the pleadings that we have filed, and the responses, either by Strang, admit exactly that chain of events. Attorney Strang that says, well, I don't know at all that Mr. Fitzgerald, to the conclusion of Deputy Shalhoub, was there in 2002. And indeed, I've got a report of Mr. Fassbender of his interview with Lieutenant Lenk on December 8th, 2006, where he tells Mr. Fassbender that from looking at the documents and from his memory, Deputy Shalhoub obtained the items from the clerk of court's office and brought them over to the sheriff's department where Lieutenant Lenk prepared the transmittal of criminal evidence. So in terms of good faith basis, I've got this witness saying the documents and his memory suggest that's exactly what happened, and that indeed did former District Attorney Fitzgerald was not the only person in the clerk's office or in that loop. If that's wrong, I guess the witness can retract it. The court says, Mr. Kratz? Attorney Kratz says, to retract what? A guess as to what happened across the street? This witness can't clear up anything. Mr. Strang knows that. If Mr. Strang interviewed Mr. Shalhoub, then perhaps he can make that offer of proof. If he didn't, I guess this court might want to know why, but not from this witness, Judge. This witness cannot, by his own, at least where the state of the record is, cannot clear that up at all. My point in stopping it at this point is I believe Mr. Strang knows that. Attorney Strang says, I know nothing of the sort, and indeed, relying on Mr. Fassbender's report of his interview with Mr. Lenk is describing a memory that Deputy Shalhoub obtained the items from the clerk of court's office. The court says, all right, it's actually Mr. Shalhoub, the way you pronounce his name. Attorney Strang says, oh, thank you. The court says, all right. So the testimony you're looking to elicit is that Mr. Lenk was under the impression that Mr. Shalhoub went to the clerk's office, picked up the items that were transmitted for which Lenk signed, but they didn't include the blood vial. Attorney Strang says, correct. They included hair and fingernail cuttings. The court says, the question the court has is the blood vial, I take it, is what's of importance here. How does the evidence you're looking to elicit tie in somehow to the blood vial? Attorney Strang says, one who goes through that court file looking for boxes of physical evidence should, or well may have seen, the box of physical evidence that was marked Stephen Avery's blood. I don't know whether Lieutenant Lenk himself did or didn't go over to the clerk's office in 2002. I expect he'll say he did not, but he's got Deputy Shalhoub evidently doing that, going over and examining this court file just 4 years ago or 3 years before the relevant time. The court says, right, I have some notes of my own the last time this came up back there in my chambers. I'm going to take just a couple of minutes to go get them, and then I'll come back. The judge then exits the courtroom, and then when he returns, says, as the court understands the line of questioning that the defense wishes to undertake, the defense is hoping to establish that Mr. Lenk may have gained knowledge of the existence of the blood vial in the clerk's office through information he may have received from Officer Shalhoub. At this point, it's true. There's a lot of unknowns as to whether the defense can link that chain, but the court believes that on cross-examination, it's something that the defense is entitled to attempt, and the state can address it on a redirect if it wishes. So I'm going to allow the questioning. Kratz says, Judge, if I may, is the court allowing this for the purpose of the existence itself of the vial of blood in the clerk's office? In other words, that this witness was aware that there was a vial of blood in the clerk's office. And the court says, well, if he says he was aware of the existence of such vial, yes. If he does not, then no. Attorney Strang then says, well, it's a peculiar question because Mr. Kratz's entire last series of questions clearly implied the existence of a vial of blood in the clerk's office, clearly implied that it was available there, and elicited from Mr. Lenk his denial that he ever went to the clerk's office or obtained any blood there. But the court says, I don't know that I would agree with that characterization. The questions mentioned a vial of blood and whether or not the witness was aware of the existence of it. But at this point in the trial, I don't think we've received any evidence that there was such a vial. At any rate, I'm going to allow the defense to pursue its line of questioning. So at this point, we can have the witness brought in and the jurors can be brought back in. Attorney Kratz says, thank you, Judge, and the jury returns at 9:43 a.m. The court says, you may be seated. Mr. Strang, you may resume your cross-examination. So here's what's going on, okay? Kratz jumps up and objects. He's accusing Strang of misleading the jury. He says this particular piece of evidence, this transmittal, didn't include the vial of Stephen Avery's blood, just hair and fingernail clippings. And if Strang is even implying that the blood vial was part of that transfer, Kratz says that's intentionally misleading. He wants the judge to shut it down right there and make a ruling on whether any of this is even relevant. Strang doesn't back down, though. He makes it very clear. He's not saying the blood went to the lab in 2002. He's saying it didn't. That's his whole point. He's trying to show that back in 2002, someone from the Manitowoc County Sheriff's Department, Deputy Shalhoub, under Lieutenant Lenk's direction, went into the court's evidence files. And in that same box where the hair and fingernail clippings were stored, there was also a vial of Stephen Avery's blood. Strang even references a report from Fassbender, one of the state's own investigators, that says that Lenk remembered Shalhoub retrieving the evidence and bringing it to the sheriff's department. So the judge kind of takes a beat. He steps out to look at his notes. And when he comes back, he basically says, look, there's still a lot of unknowns here. But the defense has a right to try and establish this connection on cross-examination. So he lets Strang go forward with the questioning. Now, Kratz then tries to clarify. He wants to make sure that the court's not saying the blood vial was definitely in the clerk's office. And the judge says no, not unless the witness confirms it. And then Strang points out that Kratz is the one who already implied that the blood vial was there in his own questions to Lenk. So it's a bit hypocritical to act shocked now. In the end, the judge says, fine, Strang can pursue it. The jury comes back in, and we're back on the record. Attorney Strang then continues, thank you, Your Honor. I will do that by marking, I think, Exhibit 214. And Exhibit number 214 is marked for identification. Lieutenant Lenk, what is Exhibit 214? It's a evidence transmittal form that goes to the state crime lab. Whose writing is on it? That is mine. When did you prepare that evidence transmittal form? September 19th, 2002. This relates to the 1985 case against Stephen Avery. Yes. This is the evidence we were discussing just before the break that Mr. Kratz requested. Yes. All right. Now, this is a form that you would have prepared, or you did prepare, to document, again, when an item of evidence is moving from place A to place B, correct? Correct. And then if it comes back from place B to place A, you would document that as well. If it came back to the evidence room, yes, correct. And this is part of something that you, as an evidence custodian or former evidence custodian, know as maintaining the chain of custody. Yes. So by chain, the metaphor is that from the moment you see or gather evidence, every person who touches that evidence along the way is a link in the chain, and you want to make sure that all the links are there. That's correct. So that when the evidence comes to court, there's an unbroken chain, if you will. All the links are present back to the time the evidence was seized. That's correct. This document, Exhibit 214, is a document intended to establish one of those links, essentially. That's correct. Now, the items that were sent on or about September 19th, 2002 to the state crime lab included hair and fingernail cuttings. That's correct. It was one box of items containing those things, correct? Correct. To be tested by use of DNA procedures according to a circuit court order, correct? Correct. You did not transmit a vial of blood to the state crime lab on September 19th, 2002? I didn't transmit anything. You didn't cause to be transmitted or document the transmittal of a vial of blood on Exhibit 214? No, I had no knowledge of a vial of blood. That is, sir, as evidence custodian, did you go over to the clerk of court's office to examine that 1985 court file and take from it the things that were to be sent to the state crime lab? No, sir, I did not. You did not personally do that? No, sir. Although you were the evidence custodian of the department? Correct. But these items were exhibits held by the court since the end of the trial? Yes, sir. Which is exactly what you wrote on Exhibit 214, correct? Correct. So you were aware on September 19th, 2002, that the court was holding exhibits in Mr. Avery's earlier case since the end of the trial? I was aware of this exhibit, yes. Actually, you used the plural as exhibits, correct? Presumably, you mean hair and fingernail cuttings? Yes. All right. When a court pulls evidence after a trial, where is that held? I don't know. Suppose that's what the clerk of court does? Yes, I would guess so. All right. Who did you send over to the clerk of court's office to obtain the hair and fingernail cuttings described in Exhibit 214? Sergeant Mike Shalou went over. All right. I'm sorry. I was calling him deputy, and I didn't mean to take him down a rank. So to your knowledge, Sergeant Mike Shalou went over to the clerk of court's office, correct? Correct. Under your direction? Yes. And then brought these items back to you in the sheriff's office? No, sir, he did not. How did you come to compare the form? The form was prepared and given to him before he went to the clerk of court's office. So you were signing this form as a transmittal of criminal evidence and didn't document what he actually obtained or sent? That's true. Entrusted him with the task? Him and the court? Yes. And then presumably that went off to the state crime lab? Yes, sir. Were you still the evidence custodian when it came back? Yes, but I had no knowledge of when it came back. Okay. Do do you even know that it did come back? I don't know if it did come back. You have no reason to doubt it? I would assume it came back. I don't know that. So would I. I mean, but you just don't know one way or the other. In relation, well, the the sheriff's department in Manitowoc County, and let's use 2002 as our time reference, September of 2002, was located in the same building that houses the jail? Correct. Just south of, what is it, 8th and Washington? Actually, it's on 9th Street, or between 9th and 8th. 9th and 8th. Okay. But south of Washington Street, if I have my directions right? Yes, sir. All right. And what's that large building that stands just to the north of the sheriff's department and the jail? I don't know, 50 yards to the north or something? It's the courthouse. Right across, sort of, a courtyard or there's a some walkways or a monument there. Yes, sir. And where is the clerk of court's office? Would be on the first floor of the courthouse? Yes, sir. Now, you were interviewed by the gentleman over farthest to the right in the back, Special Agent Tom Fassbender, on December 8th, 2006. Does that sound right? It sounds about right. Yes. You knew that a question had been raised about this vial of blood that Mr. Kratz referred to? I was informed that day by Agent Fassbender that the blood vial existed, and he wanted to ask some questions of you about that blood vial? Yes. Explained to you that an issue had been raised about integrity of this investigation? Yes. And you wanted to answer his questions? Yes. You wanted to answer them truthfully? Yes. To clear up any questions about the blood vial or the integrity of the investigation? Correct. You would be truthful in any event when answering the law enforcement officer's questions? Is that a question, sir? Yes. Yes, I would. Lying to a law enforcement officer who's performing his duties is itself a crime. Yes, in the state of Wisconsin. Sir, you told Special Agent Fassbender on December 8th that you had filled out this evidence transmittal form, Exhibit 214? Correct. Just as you told us today that you wrote on the transmittal form that the exhibits had been held by the court since the end of the trial. That's what I was told. Yes. That's what you told Special Agent Fassbender? Correct. And you told Special Agent Fassbender as well that it was your memory that Sergeant Shalou had obtained the items from the clerk of court's office and transmitted them from there. That's correct. Were you interviewed just about a month later by an investigator Steyer from the Calumet County Sheriff's Department? Could be. I believe so. I'm not sure. Which part are you not sure about? I'm not sure of the date. I know I did talk to Investigator Steyer. Fair enough. I'll show you. I guess I'll mark this, but I'm just going to use this to try to refresh your recollection. And exhibit number 215 is marked for identification. I suggest the date of that interview may have been January 11th, 2007, but I will show you exhibit 215 just to see whether or not it refreshes your recollection about Investigator Steyer interviewing you. Yes, sir, it does. Was that interview in person? Yes, sir. Investigator Steyer also, obviously, is a law enforcement officer. Yes, sir, he is. And on January 11th, 2007, did you tell Investigator Steyer that you had no idea the Stephen Avery file was kept in the Manitowoc County Clerk of Court's office? I didn't know there was a file over there. No. All I knew about is what I had sent out. I didn't know there was a file there. You didn't know there was a file, but you knew that there were exhibits from the file? I didn't know there were other exhibits over there other than the one I had dealt with. So you thought that perhaps the hair and fingernail cuttings were the only exhibits that the court had held since the end of the trial? I didn't know. I mentioned earlier that you're, in terms of rank, probably the fourth ranking person today in the sheriff's department. I'm one of 4 lieutenants that is fourth ranking. Yes. Okay. And that's where I was going. You're fourth in terms of rank, but some of the positions above you or parallel with you have more than one person filling or with that rank, correct? Yes. So that, in other words, there may be 2 deputy inspectors? Correct. Both of whom outrank you? Correct. You're one of 4 lieutenants? Yes, sir. But you are part of the scene or management team of the sheriff's department? I'm not sure I understand your question. Okay. And it may, that may not be a term you folks use. So let's start with, are you part of management, so to speak? Yes. Are you included in meetings about the overall operation of the department? Not most of the time, no, sir. Simply responsible most of the time for the operation of the detective bureau? That's correct. You are the only lieutenant of detectives? Yes, sir. Do you know, as you sit here today, Lieutenant Lenk, how many keys the Manitowoc County Sheriff's Department has to the Clerk of Court's office? No, sir, I have no idea. Do you know that the Sheriff's Department is responsible for security in the Manitowoc County Courthouse? Yes, sir. That courthouse, of course, includes the Clerk of Court's office, right? Correct. And a number of other offices in the courthouse? Correct. The Sheriff's Department has overall responsibility for security in that entire building? Yes, sir. And its offices? Correct. To maintain security or to discharge that duty, the Sheriff's Department needs access to the courthouse? Correct. Needs access to all the offices in the courthouse? Yes. Has one or more master keys to your knowledge? I would assume so. I have no idea. And in any event, you don't know how many such master keys your department may have? That's correct. I want to move to Mr. Avery's civil lawsuit, all right? And the backdrop on that is Mr. Avery being released from prison. You remember that? Yes, sir. That made big news. Yes, it did. 2003? Yeah, I believe it was 2003. And by big news, I mean, this was something that was on the televisions. Yes, it was. You recall it being in the newspapers? Yes, sir. You recall the newspapers shining a light, so to speak, on your department? Yes, sir. Examining the way that earlier conviction had been handled? Correct. You understood that your department had been the investigating agency in the 1985 case? Yes, sir. You understood that that investigative process led to serious charges being brought against Mr. Avery? That's correct. Ultimately led to his conviction? Correct. And that it turned out he hadn't committed the crimes? According to the release, yes, apparently he had not. According to the release. Ooh, somebody's ego taking a little bit of a hit here. Let's continue. Do you have any question about that? No, sir, I don't. Any doubt in your mind about whether Mr. Avery was innocent of the crimes for which he was convicted? No, sir, I have no knowledge of the case. I would not hazard a guess one way or the other. Simply a matter on which you have no opinion. Pretty much. Is this another one of those things that you didn't care about one way or the other? I would say, other than the fact that it involved my department, I really didn't care one way or the other. Okay. And that was a phrase you recall using just yesterday when Mr. Kratz asked you how you felt about or what you cared about Mr. Avery's lawsuit. Correct. Now, you remember, not the exact time, of course, but you remember the general extent of Mr. Avery filing a civil lawsuit? Yes, sir. Filed it against Manitowoc County? Yes. Relating to the actions of the Manitowoc County Sheriff's Department? Yes, sir. I believe that's what it was. That is a sheriff's office in the state of Wisconsin as a county office, correct? Yes. So you understood that the lawsuit put in issue the actions of your department? Yes. Did you care when that lawsuit was filed? I'm not exactly sure what you mean by that, sir. Did you care about the lawsuit being filed? No, sir, I did not. Didn't care at all that the county was being sued over the actions of your department? I didn't have any involvement in the case, and I really didn't have an opinion one way or the other. And you didn't care one way or the other who won the lawsuit, if I understood your testimony? I didn't say anything about caring who won or not. I just said that I didn't really care about the lawsuit. Didn't care about the lawsuit. If you didn't care about the lawsuit, then I guess you didn't care one way or the other who won or lost? No, sir. You didn't, or are you agreeing, or no, sir, I didn't care one way or the other. All right. And do I understand you to be saying that you didn't care one way or the other, then whether someone who had been wrongfully convicted got some compensation for that? I felt if he was wrongfully convicted, then yes, he should have some compensation. Then how is it that you didn't care one way or the other? I didn't really have a strong opinion one way or the other. All right. But if he happened to get some compensation, that would be all right for you? That would be fine. All right. Do you think somebody who goes to prison for a long time for a crime he didn't commit ought to get some compensation? I believe so. But you didn't have a strong opinion about that one way or the other? No, sir. Did you have a strong opinion one way or the other about the fact that the man your department missed back in 1985 was out free on the streets because Mr. Avery was doing his time? Attorney Kratz says, objection, relevance, Your Honor. The court says, Mr. Strang. Attorney Strang says, I'm exploring his attitudes about the lawsuit and its consequences. Attorney Kratz says, this isn't a consequence of the lawsuit at all, Judge. The court says, yeah, I'm going to sustain the objection. Attorney Strang then continues. Do you care one way or the other, Lieutenant Lenk, about whether your department gets the right guy in a criminal investigation? Definitely. That you do care about? Yes, sir. And what's your preference? I'm not sure what your question is, sir. Well, since you cared about whether they do or don't get the right guy, what's your preference? My preference is you always try to get the right person. Now, this was the lawsuit that eventually led to your deposition? Yes, sir. Your deposition on, I think, October 11th, 2005? I believe that's the date. I'm not positive. I won't even bother to mark this, but I don't want to have you have any questions about it. I'm showing you the transcript of your deposition. What's the date of that deposition? October 11th, 2005. That's you with your picture on the front? Yes, sir. Lieutenant Lenk was October 11th, 2005, the first time you had ever had your deposition taken? Regarding this lawsuit? Regarding anything? No, sir. I believe I had done it at least once before. Had a deposition before, all right. This was, though, something unusual for you? Yes. You were subpoenaed? Is that a question, sir, or yes? Yes, I was. And you asked, or you were asked, a number of questions? That's correct. You under You un you understand that this process here that we're doing, I'm the one asking questions. So I'm speaking to you. I'm asking you a question. Yes, sir. Okay. And you're providing answers. Yes, sir, I am. You provided answers at the deposition in much the same format, didn't you? Yes, sir, I did. And I think you told us that one sort of the major topic of this deposition was the telephone call that Sergeant Colburn, in fact, when he was in the jail, had received some years earlier. That's correct. Sergeant Colburn told you about that telephone call, didn't he? Yes, in 2003. That is, he told you about it on the very day of Stephen Avery's release or the very next day, didn't he? I don't recall. It could have been, yes. But you all were having a conversation about Mr. Avery being released from prison, right? I don't know if we were having a conversation about that specifically. No. But in any event, whether there was a conversation or not, Officer Colburn had given you this information and you thought it may or may not be relevant. That's correct. And you you told Officer Colburn he ought to pass it along to the sheriff? Yes, sir. And the two of you went to Sheriff Peterson together about it? Yes, sir, I believe we did. And Sheriff Peterson suggested that maybe the two of you ought to prepare a short report or statement about that? That's correct. You prepared that statement on September 12th, 2003? I believe it was that same day. Yes. Do you recall that, or do you not, as being the day after Stephen Avery was released from prison? I don't specifically recall if that was the same day. Did you consider the possibility that you might be added as a defendant to that civil lawsuit? No, sir, I did not. Never crossed your mind? No, sir. And at this point, this is getting quite long, and the next subject, the questioning is still being done by Stephen's attorney, excuse me. But they move into a different line of questioning, and this goes on for quite some time. And because, as I said, this is getting quite long, we'll cut it off here and pick it up right away in the next episode. So, what did we just hear? Lieutenant Lenk doubled down. He says he was surprised to see the key. He insists it wasn't there before, and he swears up and down that he never planted it. Same with the blood. He claims he never touched it, never even knew about it, and would have admitted it under oath if he had. Come on. Do we really believe that an officer would sit there on the stand in the middle of one of the biggest trials in the country and suddenly confess to planting evidence? Of course not. That's not how this works. We also learned about his role as evidence custodian, his proximity to the clerk of court's office, and how close Manitowoc law enforcement really was to Avery's past and present cases. The same department accused of railroading Avery in 1985 is all over this 2005 investigation, no matter how much they try and call their role limited. The cracks are showing. And in the next episode, as Lenk stays under cross-examination, we'll see the defense continue to chip away at the state's story. Thank you all for listening. I appreciate each and every one of you. If you haven't hit that subscribe button, please do so. It helps so much. We'll continue in the next episode. We'll talk soon. Bye for now.